Welcome back to Lost Touch Channel. My name is Anton Vieltsin. I'm an attorney in the Southern District of California here in San Diego. Today we're going to be discussing a case from the state of Tennessee. You might be asking yourself, why are we on the East Coast if we all know that I practice in California and Nevada? I'm here on the West Coast. Well, because I read all of your comments and I try to respond to as many as I can. In recent days, somebody left me a comment asking me to discuss the following case. And I have, in fact, encountered such a scenario in my own practice, in my own DUI cases. Generally speaking, here's what happens. An individual gets in a crash, a vehicular crash. By the time police responds, there's nobody around. The suspect either left on foot or in the vehicle. Through further investigation, police go to the suspect's home, and then the question becomes the blood alcohol level, whether the person was drunk at the time of the crash, or did the person get home and become intoxicated, and some other defenses. Here the question is whether police officers were permitted to enter the home under exigent circumstances because the suspect was not answering their calls. Before we go on, I want to thank you for watching me on YouTube, hitting that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, consider going to loststash.com and checking out some of the merch, including these Do Not Arrest This Person t-shirts. Thanks for watching.
Quick message from Law Stash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Law Stash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Law Stash YouTube page. That's LAWSTACHE.
Today we'll be discussing State versus Gibson. This is a case from the state of Tennessee. I will give a full citation and a link in the description below so you can click it and read the whole thing. But for now, let's discuss the factual basis and then we'll talk about the law. In the early morning hours, police receive a call of a vehicular crash. Captain Walsh responds to the scene. He sees a single vehicle crash. It seemed like the car struck a tree and then rolled over to the side of the street. There were no suspects, no passengers, and nobody around the vehicle. Captain Walsh looks at the license plate and figures out that the owner of the vehicle lives about half a mile away. To conduct his investigation, he drives himself over to the house. When he gets there, he sees that the house has the front door open, but there's a see-through security door, and he can see inside the house. It's dark inside. He then encounters a neighbor who tells Captain Walsh that he believes that the occupants, the owners of the house, are out of town. He was responsible for walking the dog twice a day, and he had a clicker for the garage. He believed that the front door was closed all the way last time he left. Captain Walsh, now worried that the suspect from the DUI might have been injured. He's worried for that person's safety. He also testified that he was worried about the break-in, so he makes a decision to walk inside the house. He opens the security door, walks himself inside. When he doesn't find anyone on the first floor, he walks to the second floor. He sees a bedroom door closed. He knocks on it, no response. He enters the bedroom. There he flashes his light and sees Mr. Gibson on the bed. He makes commands, but Mr. Gibson is unresponsive. Unable to wake him up, he calls the paramedics. Paramedics arrive. They're able to wake Mr. Gibson. Everyone testifies that Mr. Gibson seemed intoxicated, and there were, of course, evidence of the fact that he walked away from the scene because next to the bed there were shoes that had mud on them, and Mr. Gibson himself had some cuts. When Mr. Gibson awoke, he told the paramedics that he was not injured, but he did confess to the fact that he was driving under the influence. He was taken to the hospital where the paramedics conducted a blood alcohol test. Now, he argues that Captain Walsh was never permitted to enter his home, and all the evidence derived from that entry, meaning the blood alcohol test, as well as his statements, should be suppressed in the DUI trial against him. The government argues that Captain Walsh was permitted to enter the home under the exigent circumstances exception. Remember, the Fourth Amendment protects against unreasonable searches and seizures, and generally speaking, officers need to have a warrant before they conduct a search or seizure. In this case, Captain Walsh did not have a warrant. The issue before this court is whether Captain Walsh was justified in making entry into the defendant's residence without first obtaining a search warrant. The United States Supreme Court has held that a warrant is not required to enter a person's home when the exigencies of the situation make the needs of law enforcement so compelling that the warrantless entry is objectively reasonable under the Fourth Amendment. One exigency obviating the requirement of a warrant is the need to assist persons who are seriously injured or threatened with such injury. The Tennessee Court of Appeals then proceeds to give a number of citations to cases that discuss exigent circumstances. I'm not going to discuss these cases here. Instead, I'm going to give you the summary from the court that perfectly describes how this exception usually applies. It is worth noting that all cases where a court has found that an exigent circumstance existed appear to have two common factors. First, in all of the cases in which court found exigency, officers observed events obviously occurring within the residence or building. For example, cries for help, screams, loud noises, or an observation of a struggle or fight within the structure by looking through a window. Second, courts have found exigent circumstances exist when officers observed events or evidence leading directly to a structure. For example, a blood trail leading to a closed door. In this case, neither of those two factors applied. We didn't have any signs or sounds of distress coming from the home, and there was no direct evidence leading to the structure. And that's true whether we're looking at Captain Walsh first entry into the home, when he proceeds to the second story, and finally when he knocks on the bedroom door and enters. The exigent circumstances does not apply in this case, says the appellate court. Then the court proceeds to evaluate Captain Walsh's conduct under the community caretaking exception. Community caretaking can generally be classified into several categories, all of which are separate and distinct from the traditional criminal investigation or detection. The primary form of community caretaking is also known as the public safety function and is the type of the community caretaking originally identified by the United States Supreme Court. In Dabrowski, which by the way is a case that I've previously discussed on this channel, the court observed that because of the extensive regulation of motor vehicles and traffic, and also because of the frequency with which a vehicle can become disabled or involved in an accident on public highways, the extent of police-citizen contact involving automobiles would be substantially greater than the police-citizen contact in a home or office. Like the community caretaking standards that have developed in our state, this type of community caretaking described by the Supreme Court supports relatively minor or regular interaction with the police, approaching parked cars when the driver appears incapacitated or sick, or the car is functioning improperly and approaching pedestrians who appear lost, in danger, or ill. The core of any community caretaking function is when the police act to protect or assist public in some manner outside of the crime control paradigm. Something to keep in mind, while your state cannot infringe on your rights provided by the United States Constitution, your state constitution can in fact provide more rights and give greater protections than the United States Constitution. And interestingly enough, the state of Tennessee does not recognize community caretaking exception to the warrant or probable cause requirement of the Fourth Amendment. Instead, it only applies in that state if there is a consensual police-citizen encounter, which we don't have in this case. And for that reason, the community caretaking exception does not apply. The appellate court, at the end of the day, says that Captain Walsh's entry into the home was not constitutional and violated the Fourth Amendment. And all the evidence derived from that encounter will be suppressed against Mr. Gibson, including his statements and the blood alcohol test that he provided later in the hospital. If you enjoyed this video, please click like, subscribe, hit that bell notification button so next time I post, you're first to know. If you're listening to the podcast version of this recording, please give my podcast a 5-star review rating. And finally, if you want to support my channel, consider going to lawstash.com and checking out some of my merch, including these Do Not Arrest This Person t-shirts and some other products. And finally, leave some comments below because as you can tell, I do read all of them and I try to respond. Thanks for watching.